This is case number 21150712. This is Affiliated Diagnostics versus the City of Detroit. Your appearance at this time for the Affiliated Diagnostics.
Your Honor, good morning. Rula Owen on behalf of Plaintiff Affiliated Diagnostics.
Good morning to you, Ms. Owen. Your P number for the record, if you will.
P79119.
All right, thank you. And for the City of Detroit.
Morning, Your Honor. Mr. Olmstead.
You got two devices. There you go.
No. Great.
You viewed it, Ms. Olmstead. Now, take yourself off mute. I can hear you. *6 will do it. *6 will get you off mute, or see your microphone there and tap on it. There you go. Went back on. There you go. All right. It's on. We're working through the technical difficulties. So.
No problem. No rush for me.
I'll come right back to your matter. As Ms. Olmstead had to go out and come back in, so right back to yours.
No problem.
This is case number 21150058. This is Carlos Williams versus Metropolitan Group Property Insurance. The matter is before the court set on for a pretrial conference. Your appearance for plaintiff in this matter. Plaintiff or defendant?
Good morning, Your Honor. Chris Rossi on behalf of the defendant. I see Mr. Falzone on the screen. He represents the plaintiff. There he is.
All right, very well. Let me have your P number, Mr. Rossi, please.
Oh, yes, Your Honor. 59305.
Joseph Falls on behalf of the plaintiff, P80521.
All right, thank you, Mr. Falzone. Good morning to the two of you. And I see that we have this all set up for a pretrial today. Looks like there was a previous scheduling order as well. So I take it that discovery is completed. Somebody update me on where we are regarding this.
Yeah, I think discovery is pretty much complete on this case, Your Honor. I don't know, maybe, Joe, we could go to case evaluation if the court would agree to that.
Mr. Falzone?
I'm sorry, my internet connection must be unstable because I can't.
Can't hear me?
Mr. Rossi was suggesting case evaluation regarding this matter as a way of maybe getting to some type of conclusion here. Want to know your thoughts? Were you able to hear me, Mr. Falzone?
I'm sorry, everything's cutting out.
All right.
I apologize.
Not a problem. You hear me okay now?
Yeah, yes, sir.
Okay, so Mr. Rossi, in his appearance, of course, he indicated that discovery is pretty much complete. And also indicated that the parties, that he thinks that some type of mediation or facilitation might be a way to resolve this.
I don't have an issue with that.
All right, so Mr. Rossi, specifically, you were asking the court to send it to some type of mediation, or what did you want, sir?
Or a case evaluation?
All right, so I will go ahead and issue an order for a case evaluation. And you'll get that from me in the next few days. And so I'm going to send it out, give you a return date. That'll be about 45 days since. That should give us enough time in the interim. What do you think, Mr. Ross?
That sounds great, Your Honor. That'd be appreciated.
I don't have an issue with that. Your Honor, I know with my internet breaking up, is this case, the last three, the case you just called 616?
No, 08058.
That's actually supposed to be Richard Brewer's case, Your Honor, from my office.
Yeah.
I am here.
And I apologize. That's why I apologize, Your Honor.
Yeah, I'm sorry too. I think I kind of saw Mr. Falzon on there and,
All right. All right. Now his internet works better now that he knows it's somebody else's case.
right. Funny how that works.
I switched to my phone internet.
I was kidding. All right. All right. So where is Mr. Brewer?
Right here.
Where?
Judge, I am present.
Your appearance there.
Good morning, Your Honor. Richard Brewer, P3 1124 on behalf of plaintiff, and I agree with everything that's already been said. We don't have to redo anything.
All right. Well, your name that comes up is Connor Coultery, and that's why.
Yeah, I'm using a borrowed computer, Judge, because I've got 3 hearings this morning, so I got 3 laptops I'm sitting between.
All right, gotcha. So that's what Mr. Rossi, you see what these guys are doing to us this morning. You know, it's
Right. I'm getting a good flavor of it, Your Honor. You can appreciate what we're up against. It's a lot of firepower on this case right here.
So pay us.
We will. We're going to get there for sure.
All right, gentlemen. I'm going to send it over. I'll give you a date, 45 days out. I'll issue an order for a case evaluation. I take it that with the experience here, you know how to get to a conclusion.
Sure.
I'll simply issue an order. The
That'd be
return
great.
date is going to be
February 9th.
February 9th. February 9th is what I'm looking at. And that's going to be at 9:30 a.m. February 9, 9:30 a.m.
Very good, Judge.
Thank you. Thank you, Your Honor.
All right, good day, gentlemen.
Good morning, everyone.
All right, Ms. Olmsted.
Good morning, Your Honor. Sorry, I was trying to come in on my phone, my computer, but for some reason my audio wouldn't work.
Right, I saw something going on there. All right, so back on the record regarding the suffix 0712, and of course, that's affiliated diagnostics versus City of Detroit. Madam Counsel for affiliating this in her appearance, your appearance at this time, Ms. Olmsted.
Crystal, sorry,
Sorry. Trying to get your appearance on the record. Ms.
Crystal
Olmsted.
Olmsted,
Your
Crystal
number-
Olmsted on behalf of the City of Detroit, P69202.
Thank you. Thank you. Somebody else on this file is just getting a little bit thicker here. Looks like you've done some discovery and exchanged some information otherwise. So where are we?
Your Honor, I'm not sure if today this is scheduled for the motion for summary or if it's just a final pretrial, but I do know that, yes, we've exchanged quite a bit of discovery on the matter, and there was a motion, the city filed a motion for summary, and affiliated responded to that motion, I believe a few weeks ago. But I admit I'm not certain if today is a day scheduled for the hearing on that motion or not.
Unfortunately, with no fault to anybody here, this file has stuff all over the place. That's not typical. So the first thing jumping out at me is answering affirmative defenses. That should be somewhere else. So now I see the motion for summary disposition, and I do see the plaintiff's response to that motion. Have not had a chance to look at the same. But Ms. Holmes said, why don't you give me if you will, the gravamen of the motion, so information in terms of what this motion is about.
I'm sorry, Your Honor. This is why I hate coming out on the phone because you break up a lot on the phone. I'm not able to hear you. Allow me to ask you first, did the court receive the judge's copy? Because there's a video that should have been attached to that. And that's an important part of the motion hearing, or excuse me, of the motion.
I have not received that. I'm looking through the file again. As I mentioned, there are some things out of order. Look like I do have a packet that has some information. And I do have a packet with 2 videos, and that appears to be yeah, the judge's copy. Just now getting my hands on it. Looks like this was back some time ago, right?
Your Honor, I file so many things. I apologize. I can't keep it all straight.
That's not a problem. I'm just trying to figure out why I didn't get it in front of you before now. And interestingly, the thing that jumped out first and foremost was the plaintiff's response to the motion. I had to dig for the motion. The response we left right out at. All right, so give me a little bit of information, knowing that I haven't had a chance to read this yet. Give me a little bit of information regarding what the motion is about. It sounds like you very well have to look at a video or something, but tell me a little bit about what your motion is.
So, Your Honor, it's a pretty straightforward motion. It would be a C10, no question of fact, of material fact. Essentially, the plaintiff in this case, I do have him in the underlying matter I have the underlying plaintiff in a matter before one of the other judges within the 36, and it's been moved to circuit court. However, I took the plaintiff's death as part of that case, and the plaintiff gave some testimony as to how the injury occurred that was wholly inconsistent with the video evidence. He didn't know that I had a video at the time of the deposition. I did not mention it to him. And so the basis of the motion is simply, I don't like to call things fraud, but the plaintiff affiliated diagnostics case is really only as good as the underlying plaintiff's case. And if the underlying plaintiff's explanation of how he incurred these so-called injuries is wholly inconsistent with video evidence, according to, I like to quote or cite Scott v. Harris, which, states that you can't, although in a motion for summary, you are required, the court's required to take the facts in the light most favorable to the non-moving party, which is typically the plaintiff in these cases. When there is video evidence that completely contradicts that, then there is no need to submit those facts to a jury. That doesn't establish facts when you have video evidence, which we do. So that's essentially the nature of the motion. And, Your Honor, I would say that there was another one of these cases from Mark Norman which is the underlying plaintiff's names, that were submitted to I believe it was one of the other judges within the 36th. And it was already I don't even believe that Alfred Ashu even took the plaintiff's dep. He just submitted the video evidence, and the court dismissed it based on that alone. So quite frankly, I probably should have filed a motion for res judicata based on the other court's ruling based on that video. But that's the nature of the motion, Your Honor.
Ms. Denham, sounds like the argument that's being made here is that a picture is worth 1,000 words, a video is worth 10,000 words, and that the video seems to be conclusive from this Olmsted's perspective that any injury that the plaintiff may have incurred was not secondary to rising out of the operation of the vehicle.
Well, sure, if I may respond, Your Honor, to that. Okay, so I'm looking at the deposition here, and I think Ms. Olmsted and I spoke about it, but I have that this patient is a 27-year-old female that was a passenger.
What happened?
Sorry.
No, I thought
Sorry about that. I'll just please keep your devices muted. I'm in the midst of a hearing. I'll be there. I'll come to you at the appropriate time. And Madam Counsel, pardon the interruption. You may continue this time.
Okay, this is a 27-year-old female that was a passenger on a bus. She was seated towards the front. The report states that she hit her head, and then she went to a hospital to be evaluated, and then was discharged. I took a look at the video. It doesn't look like the patient in question appears anywhere in the video itself. Where she was seated is nowhere to be shown on the video. Not to mention also that there's also a several second delay when you do see the video. And furthermore, there's been no expert testimony or evidence to suggest that no injury could occur or result in an accident such as this. And without that type of evidence, there would essentially be no foundation to support a motion to dismiss. And Your Honor, just one last final point is that this is the treatment provided was diagnostic testing. And I don't believe that it's unreasonable for a person involved in a motor vehicle collision to seek diagnostic testing to affirm whether or not an injury exists. And that is the nature of the treatment provided here. That's the summary essentially of my response.
All right, and you would agree, however, that to the extent that that there is either evidence to establish that the any injury that may exist did not occur as a result of an operation of the motor vehicle, that would include affiliated diagnostics will receive recovery from under the no fault benefits act. So in other
Your
words,
Honor,
I
I'm
mean,
sorry. I'm not sure if you were asking me a question and I didn't quite hear it clearly. You're a little low
Yes,
over there.
Yes, I'm sorry, ma'am. I was asking you. You raised at the end part of your discussion that it was reasonable for the claimant to seek treatment at the affiliated diagnostics.
Correct.
I wanted to get on the same page as it relates to whether they saw treatment or not. In this case, it did. If it's established that the accident or their injury did not arise out of the operation of the motor vehicle, that then they would not be affiliated diagnostic would not be able to make a claim under the no fault act. You agree with that?
Well, Your Honor, I would agree that unless there is evidence that a collision occurred, then diagnostic treatment wouldn't be reasonable. But seeing as how there's a report, there was ambulance that arrived to the scene of the accident. In fact, a collision did occur. I would think that any diagnostic treatment following a collision that's been established would be reasonable, notwithstanding whether or not injuries actually arose.
Well, and I guess there's a separate question is whether if the treatment is reasonable, the question becomes whether or not the treatment, the cost of the treatment is reimbursable, where if it cannot be established, ultimately that injury arose out of the operation of the vehicle.
That's correct, Your Honor. And the point that I was making is that there's no expert evidence, which would be required in this instance, to suggest that there is no way that any injury could have arisen out of a bus collision or this bus collision.
Gotcha. All right, thank you, Counsel. Ms. Olson, I think that you're making the point that in the deposition, that the defendant, strike that the plaintiff indicated a certain manner in which the accident and injury occurred. Is that correct?
Correct, Your Honor.
And your argument is that that's wholly inconsistent with the evidence as presented by the video.
Correct, Your Honor. And it's not even to the point in which it is arguably slightly different. This accident was so insignificant to the point where all the passengers on the bus literally did not know what happened, and the bus driver had to explain to them that this U-Haul had struck the bus. And the testimony given by the underlying plaintiff was pretty extreme. It was fell out of the seat, and nothing like that occurred on the video. So, Your Honor, I'd ask the court just to, take a look at the video and, draw your conclusions from that. I just don't see how you submit it to a jury. I don't think we're supposed to submit things to jury if we're going to completely waste the jury's time, because that deposition was taken, it was under oath. And
Your Honor, just the last point, one last point is that the patient doesn't appear on the video at all.
I'll come back to you in just a moment, ma'am. I'm coming back to you, Ms. Am. If you might have answered my question, I wanted to ask a specific question to Ms. Armstead. Does the video show the positioning of the appearance, the occupancy or positioning of the plaintiff on the bus?
Your Honor, where she described herself as being, and it does not. So quite frankly, it's almost it's either a situation in which she was not even on the bus, or she's whatever. The way that she described her positioning is so incorrect and so out of line with what's on the video. So I would say I don't really know how to answer that question. She said she was at the front of the bus. The video shows the front, and she said she had a child sitting on her lap and she fell, and none of that takes place.
The video shows the front of the bus as the accident is occurring, correct?
Correct. And you can barely tell when the accident occurs because it's quite insignificant. It was just a slight bump.
Was it just a video delay, or that's just in real time?
It's in real time. I don't know exactly what the delay is.
All right, very well. I'll take a look at I understand what the issues are. I'll take a look at the video. Is there anything else you wanted to say?
Yes.
No,
So I have just one thing. So as to the cameras on the bus, so you do see the bus driver. You don't see who's sitting behind the bus, which is where she described herself sitting. And I'm not sure if, when looking at the video, there were video that was supposed to be pointed in that direction, but essentially it's the passengers in the middle and the back of the bus, which are showing in the video, but not whoever's sitting behind the bus driver. So she may have in fact not been there, but based on the video, we don't know who's sitting behind the bus driver.
All right. So I've got your arguments. Let me take a look at the video and get you back here. Maybe on Thursday. Thursday.
Thursday. I mean, you got a case, you can do it next week. You can do it on the 22nd. You got 2 cases.
Okay, I got to do it on the 22nd. Of course, I have a lot of cases, but I'm trying to pack this one into this week. But the 22nd, will be one, we'll take, I will have taken a look at it, read your items, and we'll make a decision regarding this matter. That's December 22nd, 12/22, 21, and that's going to be at 10 o'clock a.m.
Thank you.
That works for you guys?
Yes,
Yes,
thank you,
Your
Your Honor.
All right. Thank you. Good day to the two of you. See you on
Thank
the
you.
next week.
Take care, everyone.
Come back. You over there. On motion.
All right, the court calls case number 21-152-616. This is Kevin T. Crawford, DOPC, and Dr. Athena, Furnishes State Farm Mutual Insurance. The matter is before the court, set on for a pretrial conference on today's date. Your appearance for the plaintiff in this matter, please.
Joseph Falls on behalf of the plaintiff, P80521.
Thank you, Mr. Falls, and we finally come to you, sir. Good morning again to you. And
morning, Your Honor.
for the defendant in this matter, your appearance at this time.
Good morning, Judge William Trudgeon, P75039 on behalf of State Farm.
All right, thank you, Mr. Trudgeon, and good morning to you as well, sir. So it looks like gotten along here. You've done some discovery already. Is that discovery completed? Is that about the size of it?
We have, Judge.
we have.
Recently discussed this with plaintiff, and their bills have exceeded $25,000. And I believe, I don't want to speak for plaintiff, but I believe they are in the process of trying to remove this to Wayne County.
That's accurate, Your Honor. We sent a motion and the motion fee to 36th District Thursday of last week.
All right, I don't see what it is populated in the file, but I will take your word for it that you're trying to move this over.
If it would be easier, would Your Honor accept a stipulated order?
That's where I was going. But I'll warn you that you won't be getting a better judge, but you gotta go, you gotta go.
Listen, I mean, I'd love to keep it there, but we're over limit, unfortunately.
I know, I'm kidding. All right, so I'll anticipate the order. You can, your proposed order, and I'll sign the stipulated order to transfer it over. That's the right thing to do, given the fact that you're over the jurisdiction limit. And do you have a place we can email that I get it signed up for right away? Mr. Trudgeon, you stipulate to such an order?
Yes, Judge.
All right, so we don't have to go through the course of sending it one way, getting it signed, and so on and so forth. On the record, there's a stipulation. So you can get that right over to my clerk, and I can get it signed, and you're all set. So you have the email address?
I do not.
Mr. Fez, you should have it, sir.
I should. Is it the same one that's on the court website?
Well, let's make sure we got it right. Latifa, you ready to write it down?
Yes, sir.
TIFAH, Latifa, LATIFAH .Hunter at 36360H District Court.org.
Latifa Hunter at 36districtcourt.org.
That's correct, sir.
Okay, I will send in the order.
All right. All right. Thank you, gentlemen. Good day to you. And I'm sure you'll be back to see me at some point in the future. For that.
Yes, thank you, Judge.
All right. This is case number 21-150013. This is Visiting Angels Living Assistance Services Incorporated versus Kenneth Wesley. The matter is before the court set on for an adjourned date for a final pretrial conference in this matter. Your appearance for the plaintiff in this matter, please.
Right. Your Honor, on behalf of the plaintiff, Jim Washington, P42503.
All right, thank you. And good morning, Mr. Washington. For the defendant in this matter, your appearance at this time, please.
Good morning, Your Honor. Thomasine Jefferson on behalf of Kenneth Wesley, P42872.
All right, Ms. Jefferson, thank you. Good to see you and good morning to you, ma'am.
You
All
too,
right,
and Judge, you right. We got a good judge here.
Well, I was kidding, but hopefully with
But-
two families, especially with all the years of experience, and then of course the attorneys on this case now with all these years of experience, and really make sure that we handle things out.
Absolutely.
All right, so somebody update me. Let me know what's going on here. I know I gave you a schedule board. Where are we with that to?
Well, Judge, you did give us a scheduling order, and we sent over some documentation I think that may be helpful. I talked to counsel just the other day, and she indicated that the records and receipts that we sent over, as you know, this is a case involving a contract for services regarding to home care services. And so there was also some payments that were being provided by the Veterans Administration. Now, we've been able to corral those documents, and we've sent them over to Sister Counsel, and she indicated to me yesterday that she had received those items and that she was going to be speaking with her client to reconcile those items and to see how we might be able to narrow the issues. Hopefully, if that's the case, there's a possibility we may be able to settle it, but I will have to wait and see the results of her discussions with the client.
And that is correct, Your Honor. I believe this case can be settled. I believe there's some VA was supposed to be paying, and it's some type of mix-up somewhere.
Yeah, that would not surprise me, particularly in this particular season that we've been in. Dealing with some administrative issues that can be real challenging, especially over the last couple of years. All right,
Yes,
so it looks like you need a bit of a window, maybe 30 days or 45 days to try to work through the accounting kind of issues.
Well, Your Honor, I would ask for 45 days, if not 60. It's a matter of just going through there, matching them up. I know in the beginning, VA was only paying 4 hours. Maybe that's where the confusion is, But and then the thing about it is, after they stopped contracting with a brother counsel's client, they got another visiting angel agency, which may be some of the confusion too.
So I'd like to keep it within the 45-day horizon. And let's see what progress can we make at time. What do you think, Mr. Washington?
Judge, I think it's pretty much up. I'm satisfied with 45 days, Judge. I think it's just a matter of counsel reconciling with her client and getting back with me. So I don't control that. So I'm happy to give her the time to do it within the context of what the court is providing. And if the court says 45 days, I'm satisfied with that.
All right, so Mr. Jefferson, let's work it during that time, and let's get you back here on February the 9th, 2/9/22. And that's going to be at 9:45. 2/9/22 at 9:45. Obviously, if somewhere along the line you guys get work done, it's just submit a work in that regard. But I'd like to take a look at everything on that date and see if the court's engagement might have some impact on perhaps resolving the matter. So February 9, 2022 at 9:45 p.m.
So satisfied, Judge.
That's a good date, Your Honor.
We will do our diligent best efforts to see if we can resolve. And I will be waiting for you, Sister Counsel.
All righty.
Thank you, Judge.
Thank you. Have a happy holiday, everybody.
And likewise, I'll see you guys soon.
Okay, thank you, Judge.
Thanks. Thank you. Bye-bye.
Bye-bye.
All right, this is case number 21-157-007. This is HS Financial Group LLC versus Eric Williams. The matter is before the court on the issuance of a subpoena for a creditor's exam. Matter is set on today's date of court. It was right that the matter was previously set, and I believe was adjourned until today's date.
I believe this is a show cause today.
Got it. There you go. I do see that now, sir. It is set for a show cause hearing on today's date, having been previously set on for a subpoena, at which time the defendant did not appear regarding this matter. Counsel, your appearance for the record, please.
Daniel Weberman, P76609 on behalf of the plaintiff.
Thank you, Mr. Weatherman. I'm looking now for Eric Williams. Eric Williams, if you're on the Zoom anywhere, please say something. If anyone's representing Mr. Eric Williams, a person living on West Parkway in the city of Redford, please say something at this time. One place it says Redford, another place it says the city of Detroit. All right, counsel, it looks like the defendant again has not appeared for the show cause hearing. Sir, your pleasure at this time.
I would request a bench warrant.
All right, the court will issue a bench warrant where the defendant has not appeared as directed to do so by the court and has failed to appear at the show cause hearing as well. Accordingly, the court issues a bench warrant and sets bond on the bench warrant in the amount of the judgment in this matter. What is the judgment amount, sir?
The judgment amount is $2,185.
The court will set the bench warrant at 22, bond on the bench warrant at $2,200 cash.
All right, thank you, Your Honor. I'll have the information sent in.
Thank you, sir. All right, this is case number 21-153-471. This is Prism and Lab LLC versus City of Detroit. The matter is before the court, set on for a pretrial hearing on today's date. I think that's an adjourned hearing until today's date. Counsel, your appearance for the plaintiff in this matter.
Good morning, Your Honor. Isabel Gavrilaski, P84492 on behalf of plaintiff.
All right, thank you, Ms. Gavelowski. Good morning to you, ma'am. I have someone from the city of Detroit here. City of Detroit, if you're here. So I know somebody was here from the city earlier. Have you spoken with the other side on this today or some earlier point?
I honestly have not. I know that we were discussing probably earlier last month. We had some talks, but I haven't heard from her since.
Okay. Wow. So you had you conducted discovery already in this matter, correct?
Yes, correct.
So where are things? Are there any efforts to try and get it resolved?
I know it's a relatively small bill, so I don't see too much issue with us taking some time to resolve it.
So, who was it that you spoke with in the city? Today?
I believe it was Jane Mills.
Usually here, so I'm wondering what's going on here. How long ago was the last time that you talked with someone?
Let's see. It looks like, I believe it was at the end of October.
All right, I'm gonna ask them, maybe reach out with an email or something. You want me to just set another date?
We can do that, Your Honor.
All right, well, let's do this. Let me, it's kind of crowded. Let me bring it back next week on the 22nd. Let's do it at 10:15. Now, I'll reach out to the city, and if you would send an email or something, just letting them know that the court wants to see them.
Okay, no problem, Your Honor. You said December 22nd?
At 10:15 a.m. Yes,
Sounds good. Thank you so much.
appreciate it. Thank you.
Have a good one.
Your Honor,
Morning.
I apologize for being late. I was in Judge Adams' courtroom. I apologize.
All right, I just adjourned it. The other attorney was here, I mean, within less than 1 minute ago. I adjourned it until next week, the 22nd at 10:15. Just.
December 22nd at 10:15.
Yes, I knew that that it was unusual for someone not to be here, and so I was trying to figure out.
I apologize. I was actually on the record in front of Judge Adams. So I appreciate your adjourning it, Your Honor.
Well, not a problem, not a problem. So we'll see you next week, 12/22 at 10:15.
Okay, thank you so much.
Thank you, Council. Good day. Ms. Deborah?